Welcome, my friends and junior colleagues, particularly. Today, I'd like to share with you the views about civil cases, that is, which cases are called as frivolous and vexatious cases. And as per Frivolous and Vexatious Litigation Act, why such type of civil cases should not be dismissed at the first hearing by the court. In one partition suit, he challenged the partition, he claimed the heir, who was related as stepbrother, against the other brothers, and the said partition suit was dismissed by the trial court. Thereafter, he preferred the appeal, and that appeal was also withdrawn by the appellant, that is the stepbrother. He was represented by a hereditary lawyer who was also senior one and whose sons were also in practice. After withdrawal of the said appeal, the said counsel again on behalf of the same client, that is the stepbrother, filed another suit on the same cause of action, which was not tenable at all, and which was frivolous and vexatious litigation one. And in that partition suit, he claimed he also filed an application for declaration and injunction, praying to the Honorable Court that the property in issue in dispute be restrained from alienating, transferring, or disposing of pending the decision of the suit. The hearing was made on the said application at length, and the Honorable Court, Civil Judge Junior Division C, I won't remember the name of that presiding officer, they dismissed the said application. Actually, because of the said frivolous and vexatious litigation, it consumes the court time as well as because of such type of litigations, the other party is put to harassment and hardship. Though in the instant case, the applicant plaintiff had no case at all. It was, if suppose it was rather attracted the penal provisions of Indian Penal Code, but as no action was taken by the other defendants, that is, five defendants and mother were made parties in it, and the intending purchasers, they were also made parties in it. That suit, during the pendency of the said litigation, the defendants, because of the dismissal of the said application, the plaintiff filed appeal, and during the pendency of that appeal, as there was no injunction granted to the applicant plaintiff, the sale deeds were executed of the property in dispute. But because of that litigation, the price of that property was reduced to a great extent. So, my request to the courts, that is presiding officers, as well as the councils practicing on civil side, and more particularly by success, by their 3-4 generations were in the same profession and practicing solely on civil side, they should at least should not file such type of false and vexatious litigations. Unless and until the duration of civil suit is uncertain, there is no end at all, as asserted by me earlier, that innumerable rights and remedies are available to both the parties, and therefore and many orders are challengeable before the appellate court, and due to that the case is prolonged and heirs of the parties come on record, but no relief is granted in favor of either party. So best way is to make amicable settlement in the case at the earliest opportunity. With these views, I will pause myself here, and thanks you all for sharing my views with you. Have a nice day.